Okay, so very good morning, all. A warm welcome to all HRFI family members and our special guest, Parizad ma'am, today. As we know that HRFI is born and growing in from Mumbai and present in with the pan-India availability of its family members. Now we have crossed 85K members in across all the social media platforms that we are there, and we are growing day by day. So it is a platform which the main key agenda of this platform is to support the HR folks, be with them, educate them, enable them to handle their roles efficiently and impactfully. And with that agenda, while we have been hit by pandemic drastically, especially in India, across the world, but definitely as we are part of India, India being one of the very big sufferer of this pandemic. And we actually stood by each other. We helped each other to like comply with the new norms, new normal, and through multiple webinars that we have conducted in this course. I believe we conducted more than 75 webinars. So I, Ankita Rodra, as a part of RFI, once again welcome you all in today's session of with a topic which is something very close to my heart and something very important to all of us. That's the new labor code. And I would like to thank our partner who helped us arrange this entire forum for all of us. That is our event partner, HRD, Sharp HRD Service Private Limited, and a special thanks to the MD, Mr. Vinod Dholap. So with that, I would start their video, and then I'll introduce our key speaker today, and that would be the flow of the program. So let's please see the video from our event partner, Sharp HRD Private Limited. Just allow me a moment. I'm just sharing the video. There is a small technical glitch. So just a second.
Ankita, should I stop sharing the screen? Only then your video will come, right?
I think that is where we are starting.
Okay.
Yeah. So I'll just check now. Is my screen visible? If any one of you can confirm, that would be wonderful.
Nothing is up yet.
Just 1 second. Is it visible now?
Yes.
Great. thank you once again, Sharp HRD Services and Mr. Vinod. Now I come to the key thing of today's session, that is a very, very warm welcome to Ms. Parizad Sirwala, the National Head Global Mobility Services Tax for KPMG India. She's been with KPMG and this is her 23rd year. So, as a HR, this is something, a word of great motivation, I think, for me, that a sustainability in an organization. So I had a wonderful beginning of the day with her. It is very difficult to, at least in my 19 years, I found it very difficult to have someone in HR fraternity who deal with such a critical topic with such a bright, smiling face. So, that's a compliment for you, ma'am. And a very interesting thing which I found out about her is that her interest is into legal thriller. I mean, it's a deadly combination of tax and labor laws and legal thriller. That's what I told ma'am. Okay, so today's topic, as we know, is the new labor codes. And I'm sure that ma'am would help us and our entire fraternity to understand it, to imply at our work in an effective manner. So over to you, ma'am. I will request all of our members in the forum to please mute themselves so that we have an uninterrupted information session from ma'am. So ma'am, over to you.
Thank you, Ankita. I hope my screen is audible, visible.
Yes, very much.
Okay, so thank you so much for having me here, and thank you to all the participants for spending the time on a Saturday afternoon. I think we have started at around 11:23. So my endeavor would be over the next hour or so to run you through a structured presentation. And what we have done is, as you know, there are 4 labor codes, but I'm going to focus for the purpose of today's session on the 2 main ones, which is the code on wages and the code on social security, because that is where the maximum impact is. Let me just know if the slides are moving. Yes, okay. With this, let me also show you that, what we will do in terms of the session today is we have selected certain topics for today's session, and that will be more on telling you where we are today as far as the legislative journey is concerned. What happens? Are these codes really live? As I said, I'll take you through the details in a little bit more granular fashion on the code of wages and social security to understand the cost impact, because that's where the major financial impact is for organizations as employers as well as employees. If you can see up on the slide, these codes have brought about radical changes. They have been introduced in India by amalgamating. So India typically had a proliferation of various labor laws. The central government had around 40 plus labor laws, and state governments around 40 plus, as we understand, 100 plus, sorry. As we know, labor is a concurrent list subject in India. So basically, the central and the state government both have powers to legislate on this topic. The government's stated intent was to aim at a structural reform that balances the interests, rights, and obligations of both employees and employers, brings down some of the multiple licensing and paperwork that we are seeing today on account of numerous labor legislations as it stands today. So these labor codes are central government legislations. It's important to note that. What have they done? They have absolutely subsumed or replaced 29 existing central labor laws into 4 codes, which are the wages, social security, the industrial relations, and the occupational safety code. So the most important change to our mind is that they have now standardized a definition of wages in all the 4 codes. Traditionally, as you may know, as HR fraternity is one of the most vexed issues for employers over the years was multiple definition of wages under the relevant different statutes. As an example, under Payment of Bonus Act, you had one definition. Under Payment of Gratuity Act, you had another definition. Under maternity benefits, it was a third definition. This frequently led to so much of difficulty in setting up salary structures, as well as determining payments on what pay should I deduct the contributions towards the employee retirements. Keeping in mind this difficulty, now the code of wages, the codes have standardized the definition. We will go through it in detail. There was a fair amount of litigation on this topic, and this is the biggest impact of the codes if I were to look at it. So now at least we have a common barometer to analyze while evaluating the definition of wages. Another very significant change is the introduction of new category of employees for the first time, keeping in mind the new age workers that exist in the landscape today, which is platform workers, fixed term workers, gig workers. For example, in the Social Security Code, for the first time, the government intends to provide for universal social security to both organized and informal workers as well as gig workers. As per data that we've read, there are around 40 crore unorganized workers who currently don't have the benefit of any social security coverage. This, of course, is a step in the right direction, keeping in mind the future of the workforce that exists as of today and the dynamics associated with the same. Of course, the merging of these central laws into 4 codes does result into minimizing the compliance hassles. That's the intent and the objective. The codes do provide for electronic filing of returns and also e-maintenance of registers, which will result hopefully in ease of operation. Now, these codes, if I look at from an employee and an employer perspective, there are some beneficial provisions for employees. Example, some free health checkup for employees, depending on the category that you fall. There is a mandatory requirement now to issue employment contracts to all employees with certain details. There is an intent to have healthy working conditions for women. Gratuity will now be payable for fixed-term employees. These legislations also to try to bring in an element of gender equality. If I look at it from an employer's perspective, there are some beneficial provisions like Pan-India Contract Labor License, appointment of inspector cum facilitator, and we will see, as we discussed in the Social Security Code, there is now a period of limitation for Provident Fund claims. Unlike now, where the regulator can go back into any number of past years and open up books of accounts, there is a 5-year limitation period prescribed. Having said that, another important aspect of these codes is stringent penal provisions in case of any non-compliance, and also certain offenses have been made as compoundable offenses. This means that employers are expected to be discouraged from any non-compliances and repetitive offenses. While I will cover the history in the next slide, what is important is that these labor codes have been passed by the Parliament of India. They have received the presidential assent. However, they are not yet live. And that's the question on everyone's mind. The central government has to notify the date on which they are going to be made operational. Having said that, all the enabling aspects like central government's rules have already been notified last year. And of course, most of the states are up with their rules now. In terms of where we stand today, just to give you a perspective of the legislative journey, if you look at it, even after 74 years of independence, significant number of workers in the unorganized sector, as I said, do not have access to social security benefits. We also discussed that employers and workers are currently dealing with multiple labor legislations, resulting in real compliance requirements, which are complex, and most of the workers are not really covered. So therefore, the Second National Commission of Labour had submitted its report in 2002 on account of this numerous labor laws, and Commission recommended that it should now be integrated into 4 areas like industrial relations, wages, social security, and safety. And therefore, these codes were introduced. Actually, the Code of Wages was passed in 2019 itself. Initially, it came out in the form of 4 bills, which were also examined by the Parliamentary Standing Committee, which gave recommendations to the government. Wage Code initially was passed in 2019. The rest of the 3 bills were referred to the Standing Committee on Labour. Now, as I said, the draft rules are out by the central government. Most of the states have also published their draft rules, and we will take a look at which states are these. If you go by a lot of media buzz around this suddenly, and in one of the articles, the Union Labour Minister, Mr. Bhupendra Yadav, has recently stated that these 4 labour codes will be implemented soon. They will bring a wave of reforms, and 90% of the states have already come out with the draft rules. Having said that, it is still unclear for all of us in terms of what exactly is going to be the date. Your guess is going to be as good as mine in the current situation. In terms of the roadmap ahead, we know that there is a huge amount of anxiety in the industry. The natural questions that come in is the government going to give us adequate amount of time for transition to the new codes? Most of the organizations have also got themselves in a state of implementation readiness. However, let's take a look at some of the potential steps that the central government will have to take before these are finally implemented. As I said, labour is a subject in the concurrent list of the Constitution of India, therefore giving the powers both to the central and the state government to legislate on the topic. Most of the states and union territories have already published the draft rules. They are all draft. Under the codes, the power to make rules has been given to both central and state government. As a next step, the central government has to first finalize its own rules, which were issued last year, and they were also put up for public consultation. Simultaneously, the state governments that have come up with the draft rules have also to finalize their own rules. As you can see on the slide, point number 5, central government and state government have to issue certain notifications in specific areas like fixation of floor wage, the threshold limits for statutory bonus, the maximum limit of gratuity, all this is not yet specified. What exactly is going to be the scheme for new age workers like platform and gig workers, along with the contribution rates and the timeline? All this is still unclear. Now, as we've seen in the history of the GST reform, the government will also be required to modify and amend their websites and online portals so that the employer can go about and make the necessary compliances. This definitely seems to be a humongous and a very extensive task, because there will be numerous activities like filing returns, uploading the necessary files, renewal of licenses, and so on. We just hope that the implementation readiness is there from a government's perspective as well. There are also many areas, as we will see subsequently during our discussion, where the Industry and Employers Forum have filed many representations before the central government for seeking clarification in respect of certain areas like definition of wages, timelines for full and final settlement, etc. So this roadmap is just a visualization of what we expect the process to be. It is quite possible that the government may directly jump from point number 5 to point number 8 in our slide here and completely notify the date from which these codes will be effective. It is not really mandatory for the government to clarify the open issues and be ready with all the modification of the websites. One just hopes and waits to see that there'll be some amount of time given. In terms of the status of the state rules, out of 36 states and union territories, 22 have already framed the rules on all the 4 labor codes. So you can see the larger, Maharashtra, Uttar Pradesh, as you can see on the slides, they are all have come up with their rules. 4 states have framed rules on only 3 codes. 2 have framed on 2 codes, whereas 4 states, which are the lower ones, are really not come up with even one draft rules on codes. These are states like West Bengal, Meghalaya, and Nagaland. However, as you can see, majority are ready with their rules. So hopefully, it is expected that the progress will happen soon. With that, let me straight plunge into the code, which is one of the most discussed code ever since it was introduced. The Code on Wages actually first seeks to consolidate and simplify 4 legislations which now stand amalgamated. These 4 legislations are the Payment of Wages Act. These are the existing laws, the Equal Remuneration Act, the Minimum Wage Act, and the Payment of Bonus Act. The payment of wages, as you know, had a threshold limit existing of 24,000. It was a law largely meant to ensure timely payment of wages. Then you had the Minimum Wage Act, which was to fix minimum rate of wages in certain class of employments. The Equal Remuneration Act, where the statute was to mandate equal remuneration and to prevent gender discrimination in employment matters. And the last one, the Payment of Bonus Act, which provides bonus on the basis of profits or production or productivity to certain category of eligible employees. These 4 laws are subsumed in the Code on Wages now. Let us now discuss the key changes under the Code on Wages. So as we discussed, first of all, the code has expanded the definition of employer as well as employee, which results in a broad-based applicability of the regulations. It is now applicable to employees in both organized and unorganized sectors. In fact, the definition of both employee and employer is very wide. There are challenges around, it in fact even includes contract labor now. And there are certain provisions which apply to who's an employee and who's a worker. And that itself is a topic of quite deliberation. If you see the second point out here, the code has widened, the scope, as I said, but currently there is no threshold limit of wages, which was earlier there in the Minimum Wage and the Payment of Bonus Act. Maybe the government will come up with a separate threshold limits. One of the areas which is again very widely spoken about is that it usually takes, when an employee resigns, we all know, it takes minimum 2 to 3 months to get your full and final payment after you quit your job. However, according to this code, the employer has to pay the wages within 2 days. Now, 2 days of what? Technical reading of the law seems to be saying 2 days from your resignation. Even if I take 2 days from the last working day, we all appreciate employer systems, payroll. Payroll is on a monthly basis. If an employee has, some recoveries, how is all this going to be possible within 2 days? But this is the provision. We've already discussed that there is one definition of wages as opposed to different definitions under the Minimum Wage Act and the Payment of Wages Act. There is therefore a requirement that emerges to revisit the wage structure of the employees in view of the new definition of wages. The other change is that the limitation period for filing the claims for minimum wages, bonus, equal remuneration by workers is now enhanced to 3 years. This gives them additional time to raise claims, if any, and also correspondingly mandates the employer to maintain such records for dealing with such claims. Lastly, there is a requirement to maintain proper records under the said code, and there are penal provisions which have been laid down for not maintaining proper records. We've seen that the quantum of penalties specified under the code is also significantly high. Of course, it depends on the nature of the offense. Now we'll discuss, the definition of wages under the existing laws. If you see, the definition of wages, we know, is different in different legislations. We discussed this is causing huge complexities for employers to understand what exactly is salary, what is basic pay, what is basic wages, on what I should make the relevant contributions and calculate the benefits for employees. We also know that there is huge amount of litigation on this subject of definition of wages, even under the existing statute. You may be aware even Supreme Court case law on provident fund payments. If you see, as you can see on this slide, under these 4 existing statutes, there are certain allowances which are included in some statutes and certain allowances which are excluded in certain other legislations. For example, if you see for the purpose of ESI, all cash allowances have to be included, whereas for gratuity, there was only basic and DA which was to be included. The government intended to avoid this confusion, and therefore they standardized the new definition of wage under the 4 labor codes. However, as we analyze it together, we will realize that this has perhaps added to the confusion, and there are a lot of ambiguities and gray areas which need clarity. First of all, allow me to explain to you that this definition is now broadly divided into 3 parts. There is an inclusion part in the definition, there is a specified exclusion part, and there are conditions which limit the quantum of exclusions, which is why you see them in 3 colorful boxes on the slide. The first part on the left-hand side is the inclusion part. The second part is the exclusion part, and there are certain 11 exclusions. The third part is the conditions which limit the quantum of exclusions. There is also a 4th part, which is a remuneration in kind, and we will talk about it. First of all, if you see on the left-hand box, the scope of the definition of wages is now widened to include all remuneration, whether by way of salaries, allowances, or otherwise, expressed in monetary terms. Or otherwise expressed in monetary terms is quite a vague or an inclusive meaning. Practically, it appears that whether any items form part of the employment contract or not is no longer relevant. Everything that is paid to an employee seems to be classified as remuneration. While the term wages specifically includes basic pay, dearness allowances, and retaining allowance, it does not mean that only this will constitute wages under the revised codes. These, as I said, are just in the inclusion part. Now, coming to the middle box, which is an exclusion one, there is an exhaustive list of 11 components which are specifically to be excluded under the definition. Some of the exclusions, if you see, are actually similar to current definition of wages under various existing laws. For example, commission, retirement, retrenchment payments, overtime were excluded largely even today. However, some of them very, very interesting from an interpretation perspective. Some paid to defray social expenses, some paid to defray special expenses due to nature of the work. If you see the 5th bullet point, what does this mean? Is it, if I'm, working with engineers, is it helmets given to engineers? Is that some paid to defray special expenses due to nature of work? If I'm in the sales business, is my mobile expense or some paid? The point that I'm trying to emphasize is some of these exclusions do also create further maximum amount of ambiguity. Another very important point, and I can also caution you, the different consultancy firms, different HR consultancy firms, legal firms are also taking different interpretations because the way this section is worded is really open to technical interpretation. One of the other main points, which is going to have perhaps a huge impact financially, is this statutory bonus. Now, please note that the exclusion is only statutory bonus. Statutory bonus is typically what was paid statutorily under the Payment of Bonus Act. The rules of interpretation do teach us that if only one type of item is specifically mentioned, then does it mean that the other items get automatically excluded? The point that I'm trying to drive home is only statutory bonus is mentioned as an exclusion. No other form of bonus is specified as an exclusion. Does this mean to say to construe to say that all other forms of bonus, whether variable pay, incentives other than commission, will be included in the definition of wages, and therefore social security contributions will have to be made on this enhanced base. This itself increases the cost to the employer manyfold. However, as I said, largest number of representations have been made on this point. We should also not forget that there are various provisos in this definition which provide for quantum of exclusions. And this is where you will see, with due respect, many articles in the media getting it wrong. The technical reading of the law seems to say that there is an embargo on the exclusions, the quantum of exclusions, which cannot exceed 50% of the remuneration. That is a condition which you will see in the green box towards the right-hand side. This effectively may mean that if your exclusions exceed 50% of gross remuneration, then such excess exclusions shall be ignored. Hence, your wages may have to be at least 50%. Another important aspect in the definition of wages is value of remuneration in kind. Now, mind you, there is no definition of remuneration in kind. The way the language is drafted for this, it does leave a lot of room open for interpretation. It states that where an employee is given remuneration in kind, in lieu of either the whole or part of the wages payable to him, the value of such remuneration as does not exceed 15% of the total wages payable shall be deemed to be the wages of the employee. I will take you through the ambiguities a little later. The question that arises is, what qualifies as remuneration in kind? How do I value the same? Is it my accounting cost? Is it my tax valuation? How is this 15% limit to be interpreted? Though there is no doubt that the introduction of this labor reforms is massive and it is intended to be a step in the positive direction, but currently there are challenges which the government would do good to clarify before implementing these codes smoothly. Now, we've already discussed that sometimes employers make many one-time payments such as performance-linked incentives, ex gratia, joining bonus, etc. Therefore, abundant clarity is needed whether these one-time payments have to be included or excluded from the definition of wages, along with any other non-guaranteed payment or performance-linked payments. That's because, as I told you, the inclusive part actually is very inclusive, all remuneration, and exclusion is only for statutory payment. Now, you may also know that these one-time payments can be huge amounts, large stakes involved. They can also impact the consistency of regular monthly contributions under various social security schemes like Provident Fund, ESI, ESI, etc. We saw the specific 11 exclusions. Now what happens to, there are certain dilemmas. You can have various allowances depending on your organization. Relocation allowance is an example. Cost of living differential for employees now who begun to travel. Deputations. What all is included, what all is excluded is still a big question mark. Value of remuneration as does not exceed 15% of the wages is deemed to be found forming part of the wages. So there are certain deeming provisions which leads to further ambiguity as to whether the entire amount of remuneration in kind would be excluded or only 15%. What does one do? Again, the remuneration in kind phrase itself is not defined. So it becomes very imperative to understand what does it mean. Let's take in common parlance whether I will include car lease rentals, fuel, driver, Sodexo, meal coupons, club fees as an example, stock options, some of the most commonly items that we see is this remuneration in kind. Because this remuneration in kind has to be included in wages, again, the issue that arises is that while applying a 50% ratio of exclusions to total wages, how will I calculate this deemed wages for remuneration in kind? On what should I apply the 50% ratio? We've tried to use a very simple example out here. And let me just tell you that in all prudence, this is by no means I'm claiming the right way to do it, because we've seen it in the fraternity and in the industry. We ourselves have made representation, having worked with several colleagues, several law firms and consultancy firms. I can tell you there are 9 to 10 different permutations and combinations that are coming in the calculation of wages. This is just our view. It may not be the view of the government. So I want to just caution you out here, and therefore I have emphasized a lot on the ambiguities prevailing. Take a look at this illustration, which I have tried to put it very simply. Mr. A is an employee of an organization. His remuneration, as an example, is broken up into 110, and you can see the breakup out here. The car and the food, which should qualify as remuneration in kind, is to the tune of 20. The rest of the items, HRA conveyance, leave travel concession, sales commission, and employer contribution to Provident Fund, total up to around 50. And this, as you link it to the main definition, these qualify as specified exclusions, which were specified in the 11 exclusions that you just saw in the slide above. So you have 50 as exclusions, 20 as remuneration in kind, total remuneration to the tune of 110. How do we calculate? We first read the whole section along with all the various provisos and explanation. The total remuneration payable by the employer in this case is 110. The exclusions are 50. I will first subtract 50 from 110, hopefully, which gives me mathematically a figure of 60. Now, as you know that the exclusions cannot exceed 50%. In our case, half of 110 is 55. My 50, which is exclusions, is not exceeding 55. So I don't add back anything as deemed wages, as for the first proviso. The tricky part is the remuneration in kind. If we read the explanation, what is 15% on? In this case, we believe 15% has to be on 60, which is the net wage after the exclusion, which comes to 9 in this example. You will add back 9, but you will subtract 20, which is the remuneration in kind. So 60 minus 20 plus 9 is 49. This is one view. I'm not going to get into the other 8, 9 views that prevail, and therefore huge amount of representations have been made on this point as to how exactly do I calculate numerically my wages with different organizations having different pay structures.
Parizad, sorry to interrupt, sincere apologies. HRFI members, on behalf of the HRFI Executive Committee, this is Sahil Nair here, and this is a sincere request to all members. Please do not use the screen to draw lines inadvertently or on purpose. It's disturbing all members who are trying to pay attention and focus on the calculations and the key messages by the presenter. As you're well aware, if this continues and we can very clearly see the names of people who are doing this, we will be left with no resort but to ask you to leave the meeting, even at the extent of taking you out of this meeting. Not just that, you will also be expelled out of our WhatsApp groups. And therefore, our request to you is, this is not a children's whiteboard. We are all mature individuals here. And therefore, whether it is inadvertently or otherwise, please do not draw lines, because we cannot even read the text on the slide. Having said that, Parizad, sorry to interrupt you, but if I may request you to stop sharing screen and share again, maybe the lines would disappear, because otherwise we will have to ask people to manually delete the lines. As admin, we have not been able to delete these lines, and these lines continue. So apologies for the interruption, but on behalf of all the members who have been paying attention and making requests, I had to just come in and request you to do this. Thank you so much, Parizad, and back to you.
Is it visible, Sahil? No, thanks for this. It was indeed disturbing because I myself cannot see the slides.
Yes, it is very clearly visible now. And by mistake, even if any member draws a single line, Rao Sahib and Ankita, as the host of this meeting, will not only request you to leave the meeting, but will also push you out. So please don't do that, and let's have a very nice session like we have been having so far. Parizad, back to you. Thank you so much.
Okay, thank you so much for the understanding. Let me quickly take up another example, and therefore my endeavor was very specifically to try and include as many numerics as possible and not make it very complex, because it is indeed very technical to understand from the code's perspective. On this displayed side, I would like to emphasize on how wages are actually payable to an employee or a worker, and how significantly the impact can happen under the code vis-a-vis the existing laws. For example, if you see the wages under the Minimum Wage Act in this example amounts to 21,000 rupees, considering the basic salary, the special allowance, and the HRFI. Similarly, if you calculated the wages under the Payment of Wages Act, in this example, it was 21,000 again. And if you look at Provident Fund, because of various Supreme Court rulings, that was again 21,000 by summing up basic salary, special allowance, DLS allowance, etc. For Payment of Bonus Act, if you are to calculate the wages, then all cash allowances would be included. Also under ESIC Act, the wages amounted in this example to 27,000, because as per the existing law, again, basic salary, cash allowances were to be added. Now, if you see the code on wages, the revised wage would be, after taking into account the basic salary and the special allowance, it comes to 15,000 rupees. All other allowances are excluded as per the current revised definition that we saw. Therefore, what happens? An employee who was earlier not coming under the purview of the Provident Fund and the ESIC and Payment of Bonus Act, because his salary was over and above the wage limit of 15 and 21, is now going to be covered. So you might see an increase in the coverage of employees for ESIC, PF, and bonus. Assuming that the wage ceiling is notified by the central government under the codes for the chapters on Provident Fund and ESIC and Payment of Bonus Act, let's assume it remains the same as the current ceiling, then such an employee can come under the purview of Provident Fund, ESIC, and Payment of Bonus Act. So one is, there is an increase in the coverage. You will also see an impact on the maternity benefits, because now all this is going to be on the revised definition. You will also note that the wages for calculating gratuity will now increase, last drawn to 15,000 from the earlier quantum of 12,000. So therefore, there is also an increased gratuity payout obligation by virtue of this simple numeric example. I have further tried to illustrate with numerics on just what this impact on gratuity can look like, just to give you an idea on the cost implications that we are talking about. In this given example, let's say the cost to the company under the existing laws is around 10 lakhs of rupees, with 40% of the CTC being the basic pay, and the rest is just from an example perspective. These are various allowances. Under this scenario, the total wages considered for gratuity right now under the existing laws is around 4 lakh, which is the basic pay in this example. If you interpret the new codes and the way the wages is defined, your total wages based on which gratuity is going to be calculated increases to 7,52,000, which are nothing but the shades of yellow, because you will now have basic pay, you may have supplementary allowance, entertainment allowance also included, and special allowance. So therefore, the wages to be considered for gratuity calculation almost doubles. Now, if you want to understand the formula for calculating gratuity for a person who's completed 10 years of service, in this example, First column, existing wages, 4 lakh divided by 12 gives you a monthly salary, monthly wages of 33,000 plus. And then when you apply the gratuity formula, 15 days pay over 26 days into the number of years of service. If you do the maths, currently it amounts to 192,308. And these are just some rough and ready examples, just to give you an idea of the financial impact. Contrast that to the right-hand column under the new Social Security Code. Because you're starting with a base of 7,52,000, your gratuity by virtue of the same formula goes up to 3.61 lakhs, which is almost double the gratuity payout. My next slide is trying to demonstrate the financial impact for an organization and their employees. Let's try and understand this impact again with a simple case study. We've taken a hypothetical case of an organization having 200 employees with an average salary of around 5 lakhs per employee per annum. In this example, we're trying to analyze the retirement contribution in 3 scenarios. What happens under the current law? What happens under the new labor codes if you do nothing on an as-is basis, just to know the impact? And what are some of the possible structuring options possible under the new labor codes? Now, in the first column, in the existing law, PF and gratuity is payable only on the basic wages. In the current example, base salary at 40% of total CTC, that is 4 crore of 200 employees. So company is required to pay gratuity and PF on 4 crores. And therefore, again, the maths works out to 67 lakhs for PF, which is 12% of base, and gratuity amounts to, in this case, 19.24, simply taking 4.81% of the base pay of 4 crores. So if you were to calculate the total payroll cost, you can see it's the annual compensation plus the above retirement benefit contributions, therefore giving you to 106,724. Now take a look at the middle column. Again, because of the revised definition of wages, we've just assumed that, around 15 is excluded allowance, rest is all includable, which gives you a figure, again, a pumped up wages of 8.5 against 4. So if you do nothing, your consequential retirement cost and therefore your payroll cost and therefore your consequential net take home for employee, I think it's very self-explanatory. You're doubling the liability in terms of the employer cost almost, and consequentially reducing the net take home. Therefore, most corporates, what have they done? They have at least started analyzing the compensation structure and trying to help. Of course, everyone's salary structure is different, but if there is a possibility of bifurcating some of the allowances appropriately by maybe introducing things like employer contribution to NPS, conveyance, increasing HRA component, making your LTA larger, so most companies have one-time basic, or things like that. Whatever we can work with the exclusion specified, let's assume you can do that. You will land up reducing the reckonable wages for the purpose of retirals under the proposed codes to around 7.05, and therefore some respite in terms of the employer costs. Of course, whatever you do from a salary structure perspective also has to be blended with the tax implications. We do not want to go from the frying pan to the fire just by making changes under the proposed codes. If anything has a detrimental tax impact, that also has to be seen. Therefore, an immediate action for all organizations, and that's what we've been seeing over the last 2 years as well, that employers need to analyze this financial impact of this change from an organization's perspective and at least be ready with what they think the potential changes could be. We've already seen the huge financial impact on employers due to this change in the definition of wages, due to the fact that you now have to pay gratuity provision to fixed term employees as well, due to the fact that you have a new coverage of employees called gig and platform workers, which also come under the Social Security net. We've seen that currently PF and gratuity is on basic wages, and I'm just reiterating, due to the enhanced definition of wages, we've seen how PF and gratuity calculations are going to look like. Added to it is the definition of variable pay and bonus, what is included, what is excluded. You will also see that this changed definition of wages will have an impact on your leave encashment and overtime policies as well, because everything is now going to be calculated on a new definition of wages. Of course, leave encashment and overtime do have provisions linked with the other code as well as to what applies for workers and what for employees. And there are various detailed provisions in some of the other codes as well. The change in the definition of wages may also result in certain exclusion of items like conveyance and utilities, because that's actually coded in the wordings. This we saw is leading to a greater amount of employees falling within the Social Security net. Another large impact is if you are an organization which is engaging fixed-term employees and contractual employees, and there are detailed definitions. We may not get the time to delve into every aspect, but you must note that payment of gratuity is now being made mandatory for fixed-term employees as well on a proportionate basis. So any person whom you hire for 1 year or more, which earlier maybe gratuity was not payable, now it is payable. It also leads one to ponder whether expatriates who are on a fixed-term secondment to India but don't complete 5 years, should they also be falling within this gratuity net now. We've discussed that the government intends to come out with a new scheme for new age workers, which is the gig and platform workers. Let me quickly move to the next code, which is the code on Social Security. I know we are running short of time. The Social Security Code, it's important to know, has done away with 9 existing laws. The more commonly ones are the Provident Fund, State Insurance, Maternity Benefit Act. Now, some of the key changes in the Code of Social Security. The existing Provident Fund, pension and ESI schemes, the codes mention that they can continue for 1 year after the commencement of the Social Security Code. So currently the threshold limits under ESI and PF remain unchanged. Central government and state governments have to come up and form social security schemes for home-based workers, self-employed workers, wage workers. Aadhaar is of course going to be mandatory now for any contributions. And what also happens is that, as I said, from an employer's perspective, now the regulator can't go beyond 5 years, which is a good thing. So right now what used to happen was, as a company, you may know that the Provident Fund inspector or regulator can go back to any number of years. There are also provisions that, if you once, currently under the laws of PF, if you have opted in once for Provident Fund, you can't opt out. Once a member, always a member. That was the rule. Now they have brought about things like subject to a written agreement. Once you've opted, you might even want to voluntarily opt out. So these are some of the key changes from a Social Security Code perspective. We've already spoken about liability for gratuity for the fixed term workers. Again, ambiguities in the Social Security Code. First and foremost, I'm not going to repeat. The definition of wages is the same. So there are huge gray areas on one-time performance-linked payments. How is the wage bill going to look? Suppose if an employee resigns today and you've just paid a performance bonus, it's going to have a huge inflated bill of wages. Then we've already discussed the payment of gratuity part. The other part, payment of gratuity, wages includes basic and DA. The formula is known, 15 days pay. Now, gratuity is also calculated for past completed years of service. So there is bound to be some retrospective impact, because if an employee resigns after the codes become effective, then you will have to do the calculation on today's definition of wage, which can actually go back to past years of service. Again, the same issues around variable pay, non-guaranteed pay, what is included, when, because the quantums can be really significantly high for any one-time payment made. The third area is the payment of wages, again, the most spoken about at the time of resignation, because the codes say that within 2 working days from retrenchment, removal, or resignation, the employer has to release the wages within 2 working days. How on earth will this 2 days be ever possible? Employee will serve a notice period following a formal resignation. Payroll cycle is going to be on a monthly basis. As an employee, I will need clearances from various departments. I might have company assets that I have to hand over. How is all this going to work? How will the recoveries happen within 2 days? This again is a very important provision for which a huge amount of clarity is asked for. Next, the codes also prescribe that in a given month, the permissible deductions from the employee's pay cannot exceed 50%. And if the deductions are more than 50%, it trickles over to the next month. But in no month it can exceed 50%. This again is a challenge. What are those deductions? Senior level employees will have taxes, provident fund contributions. Clarity is, hopefully asked for out here as well. Another most widely talked about item in the media is payment of overtime. First of all, overtime is paid to a worker. It is hopefully clear that it's not to an employee. And worker is a specific definition, largely excludes people in a managerial, administrative, supervisory capacity. The government has to decide the minimum rate of wages to the employee, which is going to be fixed either by the hour. So if the worker works for more than those hours, as an example, then he now has to be paid overtime at twice the normal rate of wages. Again, this cash outflow has to be evaluated. It is not very clear in relation to this kind of a hybrid environment. How does one monitor overtime? There is an added provision that you have to obtain consent from the workers for doing this overtime hours. There are also a lot of myths around, if I'm working for 12 hours a day instead of 8 hours, and therefore I'm getting paid 4 hours as overtime every day, then can I, and the other requirement is also for a 48-hour week, then does it mean that I work only for 4 days and get leave later? There are issues like this. We've discussed around the gig and platform workers, but traditionally you must know that these are new work arrangement concepts. Largely they are people who are outside the traditional employer-employee relationship, and therefore it is important to identify in your organizations whether you are employing this kind of labor as well. Now, various functions in the organizations, but now you know it is not an easy exercise. Various functions have to come together. As an example, HR will have to look at comp structure, policies, processes. Finance may have to look at their budgeting and provisioning aspect. Payroll team will have to look at items like full and final settlement, amount of deduction, limits of deduction, dates of payment or salary. Similarly, the tax team will have to provide inputs, on the salary structure, to check the tax impact on the end. If you have to look at the compliance team, they will need to update their compliance checklist. Online softwares, offline registers, we don't know what it will be to be into a state of readiness. Legal teams are also involved. That's what we've seen in corporates, because there are a lot of factors which need to be considered, like agreements with vendors, categorization of contract labor and worker. So sum and substance, all the stakeholders need to come together to understand the nuances of these codes and commonly synergize to be able to be in a state of readiness. The last but not the least, there's a lot of planning and preparation that may be required for a smoother transition. We know that the codes may just be around the corner, or it could be miles away because the date is not known. To start with, what we've seen based on our experience, employers should start analyzing the financial impact in detail. as we have seen that there could be significant financial impact. Companies may need to actually rework their budget estimates as well as provisions that they carry forward in their books of accounts. Secondly, there is a need to review the salary structure, read with the revised definition of wages and the income tax provisions. Employers may align the salary structure in a way that the net take home of the employee is not reduced. If at all the company is planning to introduce a new salary component, the same has to be evaluated from a tax perspective as well. You can also look at evaluating alternative compensation structures from a cost perspective, because we've seen the retirals are getting hugely impacted. A lot of existing HR and payroll policies may have to be also reviewed and become important at this stage. We've seen there are a lot of changes impacting policies like overtime, full and final settlement, gratuity, leave encashment, etc. So it would be good to start reviewing these existing policies in line with the provisions of the labor code. You may also have to draft complete new policies to cover items. If you have gig workers, there may need to be a separate policy for them as well. All this, a natural corollary would be that there would be huge amount of change management and communication that would be required within the entire organization, depending on the scale and the magnitude. Until the effective date is notified, as an organization, it may not be possible to, get yourself into a state of readiness immediately. So it would be good to plan and start in advance. Lot of provisions, you might have to do training sessions for your payroll and other teams. It's also important, depending on the labor that you employ, to actually identify who's a worker, who's an employee. And for that, you will actually have to look at the roles and responsibilities. You will have to look at your vendor agreements to see if there are any legal clauses that need to be tightened up. And then you have to, of course, look at your compliances and technology. Is it in the state of readiness? With this, I'm going to stop sharing my presentation. How would you like me to, Ankita? Where are the questions? In the interest of time, because I think we started late and I do have another commitment, I'll try and take 1 or 2 questions at least.
Sure. So first of all, thank you for such a wonderful insight. I believe that there is so much of an ambiguity regarding this particular topic, and you very categorically told us what it is and exactly how it is going to be impacting the both employer and the employee and the other stakeholders possibly. So we will take the top 2 questions which we have received from the executive committee. The first one is that what is the scope of variation in the rules from state to state? Does this take away the standardization?
Yes, so there are certain overlapping or conflicting provisions, if I may, depending on the state which you have to evaluate. So for instance, we've seen, things like under Bombay shops, there is a particular item of whom you pay overtime and what the working hours should be. And the state has come out with another rule. So that's exactly the reason why there is absolute harmonization required between the central and the state government. There are also questions being asked that if you're an MNC with employees floating everywhere, with offices being everywhere, you could be an MNC headquartered in, let's say, Delhi, but you have offices in Bangalore, you have employees working elsewhere. Which state rule you have to see? Largely where the office is situated, the respective state laws have to be examined. All of them are in the draft stage. So, they were out for consultation in the public domain, but we have seen inconsistencies of variation. There is also a doctrine of, I don't want to get technical, but in cases of conflict, the central government rules should prevail. So examining the central government and the state government rules is a humongous exercise, and every organization will have to do it because certain state laws, for example, in Maharashtra, the Bombay shops and establishments prevails even after the courts. So it's a very, very detailed exercise that will have to be undertaken.
Sure. Thank you so much. The second question is that there is one member who's asking about if you can give a little insight about the platform workers.
So that's a large topic, Ankita, not
Okay.
possible to be covered here, but largely it is a person who's using a technical online platform.
Mhm.
And, you know, the whole definitions around fixed term, wage worker, home worker, platform, gig workers is actually will require a detailed 2-hour session,
Sure.
because there are definitions provided, but it's largely to cover the latest kind of non-traditional labor arrangements which are in vogue not just in India but across the globe. You might be familiar with phrases contract of service, contract for service, read with the definitions of contract labor and contractor, which have also changed. One has to actually do the non-financial impact of all these policies with a very detailed examination and exercise that will lead us to conclude what fits where. And there are ambiguities in those definitions as well.
Sure, thank you so much. Though I understand it's a large topic, but you have touched based on the key pointers. And I would request Raushab sir to please say a few words.
Yeah, hi Ankita, thank you. Thank you, Parizad. It was a really wonderful
Most
session,
welcome.
And again, thank you very much for accepting our invite with a very short notice of 3-4 days, and we could gather. We got 1,000 registration, but somehow some of the members they were facing difficulty to join the meeting. Still we had around 580 members they had joined. So for this other queries, we are going to organize a physical seminar of for 4 hours. So all your questions will get answered over there. So you have to just wait for our next announcement. Thank you very much.
Thank you. Thank you for the opportunity.
Thank you, ma'am. Thank you, everyone, for joining in. And special thanks to Parizad ma'am for making this so, you phrased out a word, planning plus preparation is a smooth transition. So thanks a ton, and we will definitely bother you a little more. And as sir said, it will be a 4-hour session. So we'll definitely have more engaging physical seminar very soon getting announced into the HRFI platform. With that, we sign off. Thanks everyone for joining in and making it a successful one. Thank you.
Thank you. Have a great weekend.
Thank you. Bye bye. Yeah.
Goodbye.